We are back to our meeting. We will resume where we left off, and this afternoon we have two individuals that we will be calling in to testify on Article 9, the sole source contract to Saipan Development LLC. Sarge, can you please call in Mr. Alan Fletcher? Please take the seats in front, right there.
Chair, if I may, before we begin, would it be proper for me to make a request of you at this time?
Why don't you sit down so we can hear you on the mic?
Okay.
Why don't I start first? I normally start even before the council speak with swearing in of our witness, and then we can go from there, stating your, identifying yourselves, and then we can go from there.
Thank you, Chair.
Thank you. I'd like to start by, before I actually ask our witness to take an oath, can I want to point out that the microphones in front of you have a button that says talk. If you wish to talk, press that button. If you stop talking, just press that button again and it'll turn off. The light on the tip of the microphone indicates whether the microphone is on. So right now yours is on. There you go. So can you turn it off? And we'll start with our witness first. Secondly, if you have any cell phones or other electronic devices that could interrupt the proceeding, I'd ask that you kindly turn them off. And also ask that even if you do receive calls, please refrain from answering the calls during our testimony, receiving of testimony rather. Okay, Mr. Fletcher, good afternoon. I'm really bad with names, but ladies, welcome and good afternoon. You will have a chance to identify yourselves. Mr. Fletcher, would you kindly raise your right hand so I can give you the oath? And press the microphone, please. Do you swear or affirm under penalty of law that the testimony you're about to give is the truth?
I do.
Thank you. You can put your hand down now. Why don't we start with Mr. Fletcher? Would you kindly state your name, your title, and the agency you represent?
Good afternoon and thank you. My name is Alan W. Fletcher, and I'm the Acting Executive Director for Commonwealth Utilities Corporation.
Thank you, sir. We may also ask your counsels to identify themselves.
Chair, my name is Deborah Fisher. I'm acting as outside counsel to Commonwealth Utilities Corporation.
Good afternoon, Chair. My name is Rebecca Wrightson, and I'm also legal counsel for the Commonwealth Utilities Corporation and an Assistant Attorney General.
Thank you.
Mr. Chairman, point of clarification.
State your point.
May we ask Ms. Fisher what law firm does she represent?
Would you like to respond?
Sure. My law firm is the Law Office of Deborah E. Fisher, and I am located at the Sablon building above the Bank of Saipan on Beach Road.
And just for clarification, both legal counsels are here representing CUC?
That's right, Chair.
You are the sort of the independent counsel for CUC, or do they call it the in-house counsel?
Chair, if I may, basically I was retained for some litigation that's just arisen called Meritita versus Video, filed in the Superior Court under index number 12-0194. And as part of that, because some of this testimony may overlap issues in that lawsuit, it was felt that it would be appropriate for me to attend. And in fact, Chair, that is the request that I actually wanted to make to you, if now is the appropriate time to do so. Our understanding is that the documents that we are prepared to furnish to this special investigative committee are confidential. And there's maybe 1,000 pages of documents. Because we do have a lawsuit that has been brought against CUC, there may be issues of liability or other issues, especially considering that the developer is one of the parties in that lawsuit to the PPA. And therefore, we would just ask that documents that we submit to your committee would be confidential so that we could preserve any privilege we may want to assert in the course of a lawsuit to protect CUC and the CNMI.
I understand. So CUC, and with the concurrence of the council, is willing to provide this committee with the subpoena duces tecum information that we requested, provided there be some form of non-disclosure agreement.
Yes, sir.
I have no objection to that, and I think we will, or the members, do you have any objection to that? I think that is well within the rights of the witness to ask, and so, Representative Sablan.
Thank you, Chairman. Just for clarification, and I just maybe the parties can make it clear, but are all the documentations that are going to be provided or have been provided to the committee going to be provided under these conditions, or is legal counsel and Mr. Fletcher going to identify which are going to be provided under the confidential disclosure agreement? So, because if everything that's going to be provided is under that agreement, then I'm just not sure where we can go with the discussion of documents provided to the committee. So, may I ask whether there will be specific instructions on what specific documents are subject to this confidential disclosure agreement?
I appreciate your question, Representative Salan, and I understand. At this point, we have possibly in the neighborhood of 1,000 pieces of paper that we have located to produce for you. That effort took quite a bit of time. And so at this time, we haven't put together any kind of a privilege log which would identify specific documents. If that was something that the committee requested of us, we could do that. But for right now, our concern is we have this giant bundle of documents. We've looked at it, of course, but as far as analyzing what may or may not cause an issue for us at some point, and this is really just about possible liabilities. We're just at the very beginning of this lawsuit, but I think that the representatives here would not want a situation where, because of some document that might have been privileged, we end up in a situation where the people of the CNMI end up having to pay money for something. And that's really our concern in this. We want to comply and we want you to have your full information, but we just are concerned about that for the lawsuit.
Thank you. Thank you. Deb, can I call you Deb? Thank you.
Of course.
You also understand that we do have already in our possession information relevant to this case or this article that was provided by CUC without the request for non-disclosure or privilege or confidential information. We have that now in our possession, and we will be discussing or asking questions relevant to the subject matter. Anything you provide us that you do want us to consider confidential, we don't have right now, or it's not been provided to this body yet. And I'm considering that for our discussions today, we will continue on based on what we already have in our possession, and that way there's no question about confidentiality. Is that fair enough?
Can I just confer for one brief moment, please, with the client?
Certainly.
Chair, we appreciate that, and we accept that. So the documents that were initially turned in, I believe it might have been to the Judiciary Committee. It's a bundle of about 421 documents.
Correct.
Those, for better or for worse, are out there already. And then the subsequent documents that we'll be providing to you would be confidential at this time.
Thank you. Perhaps at the end of this hearing, we will receive your additional information and schedule another hearing because I can't expect the members to be able to digest 1,000 pages of documents today and be able to answer questions anyway. And since we already do have several witnesses that we are scheduled to interview on October 9th related to this article, we can go ahead and reschedule Mr. Fletcher to appear then and there, and that would give us time to look at it and sign any agreement that we may have to sign. And at that time, we may even hold an executive session so that only the members here can ask questions, and it won't be publicly disclosed. Thank you. Is that fair enough with the members? So that we can proceed today? Okay, and the councils. One other question I have to our legal counsel. John, because we have Ms. Fisher and Ms. Wrightson, is it?
That's correct, Chair.
Thank you. Here with us as legal counsels for Mr. Fletcher, but because some of the information we have their names on it, email, correspondence, and so forth, can we ask them questions as sort of like witnesses? And is that admissible?
Ask the legal counsel?
Correct. They were, in fact, legal counsels of CUC, and some of the correspondence, some of the reviews of reports did indicate them as being aware of those reports.
Yes, you can always ask them, but they may wish to invoke the attorney-client privilege, but that's up to them.
Is that a yes, John?
Yes, you can, yeah.
Thank you. Okay, with that, first of all, thank you for coming and attending. I wanted to ask if we can kind of speed up the process by maybe asking if one of you can kind of run us through the events that led to the signing of this contract, just so we can have some kind of understanding and a timeline, if you will. Some of the significant events, like meetings that took place that where something was important happened, that just so we can have an understanding of how this contract came to be, and only of course from your participation. I wouldn't ask you about meetings that occurred with other individuals, but just with CUC. Is that a fair question to ask, Counsel?
Yes.
Thank you. Could you kindly assist Mr. Fletcher or have Mr. Fletcher go ahead and brief the members?
Thank you, Mr. Chair. And this is, many of you were in the room back on August 16th when I stopped by for an informal conversation that ended up to be about 3 hours of questioning. I was really tired that night when I got home. And I want to thank you for at least the opportunity to address you. And I did not bring a calendar with me, but at the same time, I'll give you my recollection. And much of what I'll say will mirror what we talked about back in August. I think it was in late June, very late June, or 1st of July, came aware of a proposed power purchase agreement, and I was brought in with the former Attorney General and some of his group in order to participate at some level in discussions. And at that time, in the first part of July, I attended, I believe, 3 meetings, at which time there was representatives from Saipan Development LLC, as well as who I assumed by their conversation, the lead negotiator for CNMI on the proposed agreement, the former Attorney General Edward Buckingham, as well as Assistant Attorney General Gil Burnbridge. And like I said, I attended those meetings, talked about different technical aspects of a draft power purchase agreement that was handed out at the first meeting that I attended. On or about July 10th, I did not participate in any face-to-face negotiations with the group and with the parties. CUC and myself, our attorney at that time, and our future attorneys, we did supply information to the negotiating team when asked, different either technical analysis or financial analysis, though none of it was detailed, but it was supplied throughout that month of the balance of July and until the agreement was signed on August 3rd.
Are you done? Okay, that was a very brief timeline, or summary rather. You mentioned negotiating team several times, that you provided information to the negotiating team. Negotiating team for the CNMI you're talking about? You said you provided information to the I just wonder who's the negotiating team for CNMI?
Well, and the term negotiating team is my term. I'm not sure if what they called themselves.
It does imply plural, though, that there's more than one person. You didn't say the negotiators.
In the meetings that I attended, there were more than one person.
Could you just please inform the members?
As mentioned, in the face-to-face meetings was the former Attorney General, as well as Assistant Attorney General Gil Burnbridge.
Thank you. Thank you. And so, just from your explanation, we gather that at least your involvement or your being made aware started sometime in late June or early July, somewhere on abouts. I do recall at the Senate hearing you talking about your participation lasted till on or about July 10, I think was what you stated. So sometime there from maybe end of June to July 10, something like that.
That is correct, sir.
And just to clarify, what do you mean by participating, or that was the end of your participation was what you said, but Alan, I know and I can expect that you had further participation meaning you're the head of CUC. They did require information from CUC. You did come on record as saying that you provided detailed analysis and so forth. So, and the records indicate you were responding to emails and providing information and so forth throughout July, pretty much, up until the signing of the contract. And I'm not trying to put you on the spot. I actually am glad that you were there to help provide information and also to advise the negotiating team as to whether what concerns CUC may have, and that's a good thing. Just one question, a general question. I understand that your authority is limited. At that time there was an emergency declaration. You do not have a board, so technically the governor is the board. He is the one for, because there is no board, he would be the board. And you've mentioned that some of the decisions that were made are not your decisions to make. That's understandable. But because you are the acting head of CUC, and you do have procurement regulations, correct? CUC's own internal procurement regulations. We earlier interviewed Mr. Sablan, who's the director, Herman Sablan from Procurement and Supply, and he's responsible for procurement and supply outside for the central government, if you will, the executive branch. But in this case, CUC is not a part of that. You have your own internal regs. And we know that this contract was a sole source contract. I just wanted to ask you, what do your regulations state? Does your regulation, and I don't know if you have it in front of you, what do they state regarding sole source contracts, or when are sole source contracts applicable?
Thank you, Mr. Chair. And first, just one correction to your earlier statement. We did provide some analysis in July at different times, and it was preliminary analysis and cursory. It wasn't detailed, and I don't want that impression left out there. CUC does have its own procurement rules, and they do differ from CNMI's, and while just as detailed, they do provide for a sole source provision, and we've used that sole source provision. But with that comes a high bar or high threshold of findings that need to be made and gone through our internal checks and processes in order for that sole source to be valid.
Thank you for that clarification. Now, with regards to the actual contract itself, the PPA and the related agreements, the maintenance and power plant development and maintenance agreement, the other related agreement. I want to ask you, you did have a chance to review it. I know that. I've seen your email, and you did have, you tried to seek also technical assistance from other parties to review it also. One of the issues that we are all concerned about is the issue of renewable energy projects. I think it's a fair question to ask if this power purchase agreement, this contract for 50 megawatt plant is valid and legal and takes effect how would that impact any future renewable energy project with CUC? Will the contract allow for renewable energy? And how do you feel about that?
The power purchase agreement does recognize that there may be other sources, and so renewable energy can still be, at this point, if the power purchase agreement remained intact, would allow for that. Now getting into my opinion is that parts of the agreement are still undefined as far as the baseload requirements and the purchase requirements of that baseload, which basically sets up a take or pay type provision of whatever power you're going to do. What's your minimum purchase, basically. That could make the integration of other renewable energy projects, at least in the short term, have a different cost and benefit equation. So there could be issues with that. One of the things that I saw with ORE, yes.
Thank you, and I think that was pointed out by Mr. Tiberius Mocano. I don't know if that's how you pronounce it, who is no longer on board, but he did send you an email. I think it was the points of significant concern, and I think he raised that point, and rightly so. But he did say that, I think the word is contracted capacity. There is the term, generated capacity, but the contracted capacity, I think, refers to what you had just said, and that is the minimum purchase, minimum purchase, minimum power. I think the term is contracted capacity. And I asked you that at the Senate, remember, if there was a minimum purchase, and at that time it was not clear. And I think when Mr. Mocano raised the issue, it was still unclear. And I think he raised the issue so that it can be clarified before the contract is signed or finalized. So I guess the question is, was that ever cleared? Do we have, what is the contracted capacity for us, for this contract? What is the minimum purchase, if you will, that we have to abide by? Or is there? Or is it unclear?
It's still unclear in my mind, sir.
And of course, we all recognize that the reason that issue needs to be clarified is because, and Mr. Mocano pointed it out, if, that would also define whether or not we can accept some alternative energy or renewable energy additional load, and how much that additional load will be, and whether we still need to pay Saipan Development with fuel for the 50 megawatts if, and we may be paying for fuel and paying for this alternative energy. So a lot of that needs to be made clear in order to determine whether we can accept renewable energy. And thank you for being frank. I think we all need to. This is not about, really, this is about us understanding whether this contract is good for our people. The other concern he raised was the operation and maintenance fee. And it said that, it says, today it was agreed that the contractor would not use an escalator. And I don't think he's referring to the moving stairs here. And would instead calculate OEM based on actual costs. He says this is great, but the contractor's actual costs need to be accounted for by an independent third party. The Public Utility Commission as a body makes the most sense to fulfill this role. It is, after all, their duty to the ratepayers to make sure that any expenses that are incurred which affect the price of rates is just, reasonable, and necessary. It says CUC as a utility has to answer to them, so it makes sense that the contractor's actual costs be approved by them as well. And I guess the reasoning is, without any regulatory body approving or disapproving OEM costs, which are operation and maintenance fees, and since the contractor is not a government entity with procurement regulations, there is no ceiling to what actual costs may run. And the analogy is, well, you know, if let's say they run out of parts, they can decide to, you know, get it right from the manufacturer when there may be other less expensive parts on the market, and they could charge us for that. And so at least there is a concern that there should be an independent third party to be able to make sure that there's no, you know, unreasonable costs that are passed on to CUC and then eventually to the ratepayers. But my question is, does the contract now address that concern? Whether, you know, I'm a little concerned because I think there is a provision in the contract that states that for all intents and purposes, this utility, this contractor, if you will not be treated as a utility and therefore should not be governed by the laws and rules applicable to utilities under the PUC law. And you see that's kind of the concern. Would you like to address that?